Good afternoon, everybody. My name is Gabrielle Nater-Bass. I'm a partner at Homburger, and I'm very pleased to chair this last session. It is also dedicated to cost allocation in arbitration. I know it's always a hard challenge to chair the last session, but I can assure you with this esteemed panelist and, of course, our excellent preparation, I will keep the audience captivated. We have had a perfect introduction by James Carter. Thank you very much, because you have actually released me from my duties to introduce the topic. There's not much more to add to introduce the topic. We're all in agreement that arbitration costs are a tremendously important topic of highly importance for the parties and, of course, also the Council, because nowadays arbitration have become extremely expensive. So it is, of course, absolutely correct that there is a huge wish and expectation to bring in more stability and also more predictability. We have heard a simple and easy approach, which, of course, is an approach that can be discussed. And we will try now within the topics that we are addressing, the cost allocation and whether this current practice we have heard is on the right track, maybe to bring in some more light and some more predictability. We will do that with the help of our esteemed panelists, and I have now the pleasure to present them to you. We have right here on my left Anja Håvedal Ipp, who is a legal counsel at the Arbitration Institute of the Stockholm Chamber of Commerce in Sweden. She manages the administration of approximately 60 arbitrations per year, including several investor-state disputes. Anja was previously an associate in the global dispute practice of John Day in New York and holds a Juris Doctorate from Columbia University and an LLM from the University of Amsterdam. Next to her, we have Massimo Benedettelli. Massimo is a name partner of ArbLit in Milan, a boutique firm specialized in international arbitration and cross-border litigation. He is also a full professor of international law at the University of Aldo, Moro, Bari, a member of the ICC Commission on Arbitration and the author of books and articles in the field of international arbitration, conflicts law and EU law. Before joining ArbLit, he has been for 13 years a partner at Freshfield. He regularly acts as counsel and arbitrator in ad hoc and administered proceedings. Next to Massimo, we do have Philippe Cavalieros. Philippe is a partner at Winston and Strawn's Paris office. In addition to counsel work in arbitral proceedings, that means ICSID, ICC, and most major rules, he is also regularly appointed as an arbitrator, including as a chair. Before joining Winston, Philippe held the position of a general counsel of Eurasia and the head of the International Arbitration Department of Renault Group. Philippe is also a former secretariat member of the International Court of Arbitration of the ICC. We all agree with this background. He has gained a 360-degree perspective on international arbitration. Philippe, and that's important for our contribution in the discussion, has also co-chaired the ICC Commission Task Force, which issued the report that was also mentioned by James Carter before, the decision on costs in international arbitration. And finally, we do have Piotr Nowaczyk, who has over 20 years of experience in arbitration. He has acted in more than 250 arbitrations as chairman, as sole arbitrator, as co-arbitrator and counsel on the rules of more than 30 arbitration institutions. Since 2015, he runs an independent practice as full-time arbitrator, mediator, and FIDIC adjudicator. Before that, he was one of the key partners of Solon's legacy firms of Dentons. Piotr served also at the ICC Court in Paris as the Polish member for 12 years and is the past president of the Court of Arbitration at the Polish Chamber of Commerce and Polish delegate to the UNCITRAL II Working Group on Arbitration and Conciliation. We have decided that we divide our subject of today's panel discussions into 3 subtopics. First, we briefly go again into the models of cost allocation and scrutinize whether what we have heard is the most common practice, whether cost follow the event is truly the best solution. Then we would like to go into really practical aspects what cost factors should be taken into consideration, and at the end, touch upon this delicate issue about costs and transparency, what is expected and what needs to be accomplished. Each of these topics will be briefly introduced by one of our panelists, and after that we're going to have a discussion, a hopefully lively discussion, where I ask you, the audience, please to participate anytime. So we will not have separate time for questions, so I hope that you, whenever you think there is a question you would like to raise, please raise your hand. With that, I hope you have an enjoyable and lively conversation. Anja.
Thank you. So you know that cost allocation actually also has an impact on VAT issues. So I could talk about that for 5 minutes, but then I think that everybody will probably leave the room. So I will not talk about VAT anymore. But so representing an arbitral institution, you often sort of get to hear the complaint of how expensive arbitration is. And I'm sure that you guys are familiar with the Queen Mary survey, and a couple years ago, something like 70% of the respondents stated that high costs was the main downside, or the worst part of arbitration. So costs are definitely important. And but as James said previously, it's important to distinguish between the two line items in arbitration costs. You have the procedural costs, you know, the arbitrator's fee and the institution's fee, on the one hand, and on the other hand, you know, party costs, counsel fees primarily. And at least in SEC arbitrations, our experience is based on our statistics. The first line item is 20%. So procedural costs are 20%, and party costs make up 80% of the total costs. And I read in the ICC report that the numbers are similar in ICC arbitrations as well. So it's important to remember that, you know, when we talk about cost allocation, the main part of sort of the main issue in the center of the debate is really the party costs, right? So be that as it may, I think so costs are significant, and so is the question of who is to pay these costs. And James introduced the two different models. So I won't talk about the models or the justification anymore. But so most arbitration rules provide for some form of cost shifting. I am not aware of any set of rules that codify or that provide for the American rule. So there are no rules that stipulate that as a default, the parties should carry their own costs, and that the procedural costs should be split 50-50. So all the rules provide for some form of cost follow the event. Now, within that category, there are some rules that include a rebuttable presumption that the loser should pay. Both the arbitration costs, the procedural costs, and the winning party's fees. And so that kind of a rebuttable presumption is in the CTAC rules, in the LCIA rules, and the UNCITRAL rules. I think it's also in the DIS rules. And then so that's the rebuttable presumption sort of category. And then there are other rules, such as the SEC rules, and also the ICC, ICDR, and the CIAC rules, that they authorize the tribunal to allocate the cost, but there is no presumption as to how the cost should be allocated. So that, of course, gives the tribunal a tremendous amount of discretion, right? And it also makes it very difficult for parties to predict how, you know, on what basis and when the costs are going to be allocated. So, given this kind of this broad discretion, I thought it would be interesting to look at how tribunals end up apportioning costs in practice. And the SEC statistics that you referenced previously are unfortunately quite misleading, because that's only investor-state disputes. And I think most tribunals would be very reluctant to impose or it's just a different consideration, I think, in those cases. So, but we have another study of 80 awards, SEC awards, rendered. So the study came out about a year ago, so it's fairly recent. And of these 80 cases, in 45% of those cases, the losing party was ordered to pay the cost in full, right? So that's almost half. That's strictly loser pays. And in the remaining half, there was some sort of apportionment, right? And so it's either split 50-50, and that happened in 20% of the cases, or there was a more sophisticated allocation analysis in 35% of the cases, right? So this latter option, the sophisticated, the more intricate analysis is what the other speakers will focus more on. But suffice it to say that, so this happens in 1/3 of the cases, of SEC cases based on the study. And this is where, the claimant may win on liability, but only proves some of the claim damages. Or, the claimant brought 10 claims and prevailed only in 6. Or, either party, or each party prevailed in some of the issues, some of the claims and counterclaims. So, and then, of course, in addition to the relative success of the parties, there are also other factors that tribunals take into consideration. So I think, is that 5 minutes?
Yes.
In sum, I think that the SEC experience demonstrates that tribunals, given wide discretion, there is a definite tendency to order the loser to pay, and that's in cases where there is a clear loser. It's obvious to point to the loser. And I should also say that that happens more frequently when the loser is the respondent, right? And when there's no clear loser, the case is not so clear-cut, then the tribunal will consider lots of factors in allocating the cost.
Thank you, Anja. I think, as Anja just concluded, and I think what we also sensed out of Mr. Carter's presentation is, it is a fact, no matter whether we find the cost follow the event solution already predicted, in the institutional rules, the arbitral tribunals enjoy considerable discretion, if not full discretion, in determining the cost and the cost allocation. And the question is, as we all are striving for more predictability, should there be some form of guidance exactly for the sake of predictability and maybe also acceptability? What do you think, Philippe?
Yes, thank you. There is no question that arbitral tribunals enjoy full discretionary powers in deciding on the allocation of costs. But it is true, and I think we have heard it this morning from Alexi in particular, and just now from James, that there is a need for predictability. So how do you reconcile both, and how do you make sure that a party, and when I mean a party, I mean a user who comes to you, the general counsel comes to you as a lawyer and say, look, I have this arbitration, how much is it going to cost me? Once you are more or less able to answer the question by looking at cost calculators online, the next question is immediately, well, if I win, and I understand that I may not necessarily win on the merits because this is a purely legal issue and there is no black or white arbitrations, will I be able to be reimbursed the legal fees that I'm going to have to pay to you? And to that, I think many of us in the rooms are confronted with the question of what do we respond? What do we respond? And there is, up until recently, there was a limited amount of documentation and statistics as to what approach is actually endorsed by arbitral tribunals. And Anja has just mentioned that costs follow the event in international commercial arbitration is widely used, and I think the report that you have referred to, the ICC Commission report has established that, and James already touched upon this issue, that the vast majority of ICC awards, I think more than 500 awards were studied, have chosen as a starting point the cost follow the event principle. In 91% of the Hong Kong International Arbitration Center awards, the same was true. Same for the SIAC, 90%. And of course, those institutions who do have a rebuttable presumption that costs follow the event are naturally inclined as a starting point. But this said, the wide discretionary powers of the arbitral tribunal can be limited. There may be an agreement between the parties in the underlying contract, in the arbitration clause, in respect of allocation of fees, and that prompts the arbitral tribunal sometimes to be careful, because under certain laws, and the English Arbitration Act in particular, the Hong Kong Ordinance, agreements prior to when the dispute has arisen, for whatever that means, are sometimes considered to be contrary to such laws. There may be institutional rules who provide some guidance. Terms of reference, the parties may of course agree. There may be other soft law, and the IBA rules, for instance, on the taking of evidence, provide that a tribunal may order costs if a party has proven to fail to act in good faith in the document production process. So, save for those limitations, full discretionary power, what do you do in terms of predictability? And I think the answer is relatively simple. I think you should discuss it with the parties at the outset. I think we will discuss that a little later as to how this can be done. But I think if there is limited amount of information available for the parties, the very least you can do for your client, even if it's perhaps too late for the client, but the very thing you should do is raise the issue with the arbitrators, or the arbitrators, even better, should raise the issues with the parties at the outset.
Yes, we will address that topic a bit slightly later, but I would like to know from Massimo, I mean, predictability, you gave us certain guidance, Philippe, on where to look at, but what is your view, Massimo? Where do the arbitrators get the standards, to actually accommodate that request, that legitimate request from the parties to increase predictability?
Yes, before we started, we were supposed to not to be academic, and when you have a panel of people where there is one professor, I think the message was directed to me. I don't want to be academic, but I think the statement that in this field we are in a sort of area where there is, as you said, full discretion, it's correct, but should be limited in this sense. The alpha and omega of arbitration is party autonomy on the one side and enforceability of the award on the other side. And this is always true for all problems we may face as counsel or as arbitrator. Now, party autonomy can be exercised in this field. As you mentioned, there may be arbitration agreements where already the parties, if well advised, try to address the issue. But we should not forget that if the arbitration is then going to be managed by an institution, you may have mandatory provisions of the arbitration rules, which the parties cannot derogate to unless they decide not to go on with that type of arbitration. And then there is state law. State law, sometimes, you mentioned Article 60 of the English Arbitration Act that says you can, of course, provide contractually that one party bears all the costs, but this has to be done after the dispute has arisen. If this is done before, this is null and void. So if you have an arbitration tribunal sitting in London, this is a provision that parties should keep in mind, because in the hierarchy of sources to be applied, this, of course, is of primary importance, because at the end, a part of the arbitral award will not be enforceable in England if it goes against this provision. And there is another area that parties should always consider in this matter, because cost and barriers to justice resulting from cost factors can also be considered something which has a human right dimension. There was a case decided in Paris by a court of appeal many years ago where an impecunious party that could not fund an arbitration for the simple reason it did not have money anymore was, of course, under administrative arbitration, foreclosed the possibility of seeking redress. And the issue was, is this consistent with Article 6 of the European Convention on Human Rights? Because if the Court of Human Rights in Strasbourg has declared already arbitration as a functional equivalent to court justice, then all the protections that are embodied in Article 6 on fair trial, including the protection parties should be granted access to justice, apply also to arbitration. Of course, don't want to open now a can of worms. Commercial companies, if they accept to go into arbitration, accept also the risk of, when they are insolvent, not being able to get justice. But this is a dimension that we should consider, because when you enter into the area of human rights, this is normally pertaining to the public policy of many legal systems, and so may have an impact on the enforceability of mechanisms for the allocation of the costs.
Thank you, Massimo. I mean, let's assume now we are in a jurisdiction where there are no mandatory provisions not allowing the parties to enter into an agreement on the allocation of costs. I mean, how common are such specific pre-dispute agreements on the allocation of costs? Anja, do you have any experience with
I
those?
would say, so this Article 60, of course, is relevant if you're in London, but it's the only national law that, including, plus Hong Kong, which is based on English law. Like in all other jurisdictions, these agreements are actually okay. I can't say that they're very common in SEC arbitrations, but we definitely see them. So I would say, and this is not a statistical study, this is based on my, my gut feeling of what I see, I would say that maybe like a handful, say like between a handful of arbitration clauses of each year, I see about 60 or 70, so that makes you know, almost 10%. Have some sort of, or they address the issue of costs, right? Now, many of these are employment disputes, and of course, those are unequal parties, and so the employer is always going to carry the arbitration costs. But you also see it in commercial cases, actually, where the parties agree in advance that they carry, usually it doesn't address the procedural costs, like those can still be allocated, but the party costs. It says the parties should carry their own costs in the arbitration. So yeah, we do see that. It wouldn't be enforceable in England, but
which
in
is not
Sweden
a minor. It's not a minor jurisdiction.
It is not a minor jurisdiction.
Can you probably educate me in which contexts do you see such pre-dispute arbitration cost agreements?
I mean, I would say that it's of course more common in you know, in contracts between parties that aren't exactly equal, like in a franchise relationship, for example, but also in like in a regular commercial contract, you know. But I would say that it's more common in smaller transactions.
I would really be curious to be educated even more and to learn whether in the international commercial arbitrations, who has actually encountered such cost agreements by the parties? Can you raise, please, your arm?
I did.
Okay.
Yeah.
See, I'm positively surprised because I have hardly ever, I think only twice, seen in my 20 years career such an agreement, but there are. It's interesting. Before we go to the last topic, one question to you, Piotr. I mean, we have also heard about a proposition made by Mr. Carter that the cost decision should, in general, be left for the end of the arbitration. I mean, what is your experience as an arbitrator? Do you think this is the right approach, or are there exceptions?
Well, it is a difficult question. I was impressed by James' presentation, and I was also panicked by the number of question marks he put both orally and in writing into his presentation. And he left 5 of us to answer all these questions in front of this competent audience. The issue of predictability, of course, is quite important. And we all would like to have a clear picture how the cost would be allocated at the end of the game, However, how can we do it at the beginning of the game? It is quite difficult even for the parties to present or to forecast the figures or the number of hours they will spend in the future for this case. At the beginning of the arbitration, it is even more complicated because usually the claimant spent more time already on the preparation of the case. Usually the claimant works for his claim for months or sometimes for years, and he or she selects the right moment to lodge the request for arbitration. Usually it is at the Christmas time or shortly before, just to trouble the potential respondent very much, to block his budget for the next year, to warn the auditors, and to spoil the Christmas celebration at the company. Surprisingly, the number of new cases brought in late November or December proves my theory. Then the number of withdrawal or non-payment on the arbitration fee comes on the month of March or early April, 3 months after summons sent and distributed by the institutions. But coming back to your question, at the beginning of the arbitration, the claimant knows better than the respondent how much it already spent and how much he or she anticipated to spend, whereas the respondent is in a different position when sometimes it is surprised by the request, has to organize the defense in a in much quicker and spontaneous way, and it could be premature to request for two parties, especially from the respondent, to have a clear picture of what it will be spent in the future.
More talking about, I mean, really cost decisions on the tribunal. I mean, as we all know, it's very, very usual that you only come with a cost decision at the end of the arbitration proceedings. But I'm really asking myself whether there aren't certain circumstances where it's justified, you know, to make a cost decision at an early stage. Maybe at some negative consequences that if later on at the end of the arbitration, again, of course, a cost shifting takes place, because if you then look at the substantive matter of the case and the decisions the tribunal had to take, you may then have a party, you know, allocating costs or let's say respectively fees again to the other party, which could have in an overall set of situation be taken care of also at the end. But Philippe, what do you think, for example, with regard to interim measure proceedings? Should they lead tribunals or prompt tribunals to take cost decision at an early stage, because one could provide and see this as a very distinct separate procedure?
I think the power of the arbitral tribunal in respect to cost decision is extremely important in order to make sure to guarantee the efficiency of the arbitral process. And if in particular cases or circumstances when faced with dilatory tactics or various sort of interim applications, if the tribunal considers that such are indeed frivolous, I think it should send a strong message to the parties, and in particular to the party that is at the origin of such requests, and issue cost decision on a phase-by-phase basis. Now, this is not necessarily true for you know, your bread and butter arbitration where everything goes relatively smoothly, but I think it's a strong message to the parties to either warn them or actually do it when faced with such procedural conduct.
Thank you. Now we are talking about one factor of cost allocation, and this leads us to the next subtopic that we have identified: what cost factors should be taken into consideration. And Philippe will give us an introduction to this topic.
Yes, other than the parties' agreements, of course, that we referred to earlier, James mentioned, and rightly so, the relative success and failure of the parties. and immediately said that this may indeed be very complex in cases involving multiple claims, multiple parties, counterclaims. And there are various ways of dealing with that. Some arbitrary tribunals consider only the primary, the core claim, and who actually won on this primary and core claim, and make their decision on cost based on such core claim only. Other tribunals prefer to follow a claim-by-claim basis. And other tribunals also like to apportion cost against the damages originally claimed and apply sort of a proportion and said, you know, you've claimed for 1 million, you only won 800,000, hence, you know, I'm going to award you 80% of your legal fees. The second aspect that is, I think, widely accepted under all arbitration rules is the reasonableness test. Were the legal fees reasonable in the eyes of the arbitrary tribunal? This is a standard that is widely applied, but of course there is one difficulty immediately, is that there is no definition of reasonableness. And therefore a sort of a common sense approach is adopted by arbitrary tribunals, and common sense varies a lot. And I can tell you that when I got my first arbitral appointment 10 years ago, I was working as a GC, and I looked at the counsel fees and I said, oh, this is enormous. And today I work for a US firm, and I look at the fees, I said, this is not unreasonable at all. So it varies. It varies according to your background, your personal background, your culture. It varies according to a number of factors. I mean, one day you just may consider that this is unreasonable because it represents 3 times or 4 times your own fees, and this is unfair. So this is a difficult issue to determine, and I think James' proposal to divide between costs of the arbitration and legal fees is good, but when assessing reasonableness, I think the arbitrary tribunal has a duty not towards the institution or the center administering the arbitration, but towards the institution of arbitration, to make sure that the legal fees presented stay within some reasonable figures and reasonable numbers. Otherwise, you know, there's already very strong criticisms on arbitration, particularly in investment arbitration, on the legitimacy of the process. And I think arbitrary tribunals should bear that in mind. Other factors come into play, management costs, but I think we will discuss that later. How the costs are presented, the proof or the evidence submitted, and this is one of the issues that can or should be discussed at the outset of the proceedings, because you know, one party may submit an extremely detailed cost assessment with receipts of restaurants bill and so on, while the other party may submit an Excel spreadsheet with final figures. And finally, and perhaps most importantly, the conduct of the parties is to be taken into account. The ICC has made a strong effort to encourage arbitrary tribunals to do so by incorporating in the 2012 rules the possibility for arbitrary tribunal to take into account conduct. So what is conduct? Then again, I think this may prompt questions, but how far can you go before the arbitration? Can you take into account pre-arbitral behavior? It's a widely debated topic. Again, the Hong Kong Arbitration Ordinance provides that arbitral tribunal may allow costs incurred prior to the commencement of the arbitration. Other arbitration rules are generally silent. What do you take into account once the arbitral process has started? Guerrilla tactics, we mentioned, post-formation conflicts, unsuccessful and repeated challenges, ex parte communications. I mean, it's as wide as one would expect. And also one can take into account, this very often happens, improper conduct during the document production phase where parties destroy evidence or fail to provide evidence. So conduct is very important, and I think arbitral tribunals do tend nowadays to take into account more and more the procedural conduct of the parties when allocating costs.
Thank you, Philippe.
I agree with Philippe totally, especially if we consider an international arbitration between the parties, I would say, on the same level. However, it happens in the international arbitration in the developing countries, for instance, like I give you an example of India, where one party hired London-based barristers charging 700 pounds per every hour, including flights in first-class category, whereas the other party was represented by a Bengali law firm charging less than $70 per hour. Then there is a real issue for the tribunal, what to do, how to deal with such disparities of the expenses brought by the parties, especially if the award partially awarded what the claimant wants and partially dismissed the claims. The same considers counterclaim and so ever. Then the issue of reasonableness of the expenses present a real challenge for the tribunal.
Thank you. I think this is truly interesting. I mean, it's going to be extremely difficult for tribunal to deal with such imbalances and to ask themselves the questions whether, whenever they find an imbalance of cost, because, for example, one party is represented by very, very expensive legal counsel, etc., whether this means per se that it's now unreasonable, these costs that have been demanded in this arbitration. I mean, Anja, can you shed some more light? How should reasonableness be assessed? Is there a way to assess reasonableness at all?
I mean, I think it's extremely difficult to. There's no way to formulate a standard, and that's why it's what the previous speakers talked about. But I also think that to some extent, I don't know if it is the role of, and I'm playing devil's advocate here, Philippe. I don't know if it's the role of the arbitrator necessarily to police, to play that policing function, to sort of guard against rising costs in arbitration. To some extent, isn't it the parties, the users, ultimately, when it comes to reasonableness, when the parties incur the costs for the £700 an hour lawyer, they don't know whether or not those costs are going to be reimbursed. So, and the parties are usually sophisticated businessmen or businesses, companies, right? So you would expect them to act with sound business judgment or in their own business judgment. Mm-hmm. And to them, it is reasonable to pay £700 an hour. So in a way, as an arbitrator, who are you to question, their understanding of reasonableness?
So I understand that your argument is the imbalance per se does not, should not.
I think it's crazy. Don't misunderstand me. £700 an hour, but
it depends on which side you are.
Exactly.
That's true.
Philippe, you want to comment on
that? Depends a lot. Also, again, we go back to the issue that we'll discuss later, perhaps, of predictability, because it depends a lot from where the parties are coming from. Because parties going into arbitration very often have certain background in terms of normal court litigation, and in many legal systems, factors like the subjective position of the party are taken into account when the judge has to allocate the costs. And so you may have a presumption that, I don't know, the Bengali party perhaps has a tradition where the fact of being a financially weak party is considered when the court is allocating costs. Of course, arbitration is different, but in terms of predictability and of defending the institution, as you said, it's a mission that we all have to keep in mind. To give this type of surprise to a party perhaps is wrong.
What is your view, Philippe?
Yes, Anja, you're right, but I think that there is a joint responsibility of all players involved in arbitration. I think it's time to realize this, and you're absolutely right that the first people responsible are the users themselves, and I can tell you that it's too easy as a user to complain about the costs of an arbitration when once it's in the hand of your lawyers, you don't want to deal with it. And you shift the responsibility, if not the liability, to your counsel. So the first party who should be very wary of costs are the users themselves. But then lawyers should also, although it's a business and we are all in the business, all the lawyers as a whole, and lawyers often act as arbitrators, but lawyers should also be wary and conscious about costs. The institutions should as well, and some institutions have taken steps to be more efficient in this respect. And I think the arbitrators indeed have a role to play. And if all those four parties in an arbitration realize that some efforts need to be made, then hopefully criticisms will fall.
Speaking about reasonableness, there are also many situations where you learn as an arbitrator that there were settlement offers made and maybe reasonably or unreasonably be rejected, often also referred to Calder Bank offers. Massimo, what is your view? Should such conduct also be taken into consideration?
But again, that's again has to do with predictability, because if you are in an Anglo-Saxon context, you may have both parties, or their counsel at least, aware that an offer to settlement made without prejudice but for costs during the arbitration may have this impact because there is case law and so on. But if you have a situation where this happens for parties who have no idea that there may be this sort of sanction, for those who don't know, the Calder Bank offer is an envelope where a party puts a sum which would be ready to settle. If the other party is refusing that offer, then, and the arbitration goes on, the higher costs paid by the losing party are to be charged to the winning party, because the winning party could have avoided all these costs simply by accepting the settlement. Now, this is a very interesting mechanism. It may be used to make everything more efficient, but has to be known by the parties, because if parties are not aware of this instrument, they may perhaps behave in a way which triggers effects they could not foresee.
Thank you. Let us go into some more trickier issues. One hot topic discussed is always, to which extent is it appropriate to take into consideration internal party costs, lost executive time, as it's sometimes called, or simply, cost of an employee that has been dedicated to assist outside counsel in preparing arbitration. Philippe, what's your view on that?
Well, I certainly believe that management costs or internal party costs may be taken into account by arbitral tribunals. One difficulty is first to consider whether such costs incur or a disruption of a company's business. I mean, going to arbitration, is that a disruption of its business, or is that the normal course of its business? A legal department, for instance, that decides to file an arbitration, is that within its mandate? Is that part of its job, or is this something exceptional? But I think it all depends, and it depends on the extent to which such executive or people or in-house counsel or project managers are involved in the arbitration. And there are huge arbitrations in which for a couple of years or 3 years, one person from the company is dedicated to this arbitration, is actually managing the arbitration together with outside counsel, or maybe an expert. It may be the contract manager who supervised the construction over several years. And during that period, that particular person is not doing any other business for the company. And the executive, the top management of the company may see this as a cost. Now, the problem is, how do you record such cost and how do you present it to the tribunal? And oftentimes when parties try to present in-house counsel cost or management costs to the tribunal say, you know, I'd be ready to consider it, but give me some evidence or some proof. And that very much depends on internally whether the company is able to dedicate a special budget with hourly rates, corresponding hourly rates, and expenses, and is able to provide evidence to the tribunal. And I think in most cases, you don't see this kind of in-house counsel cost being taken into account because simply there is no evidence. And so this is another topic that maybe in certain cases, not all cases, but in certain cases may be worthwhile discussing at the beginning, and the tribunal may give some guidance to the parties. If you're going to have in-house counsel cost, let's agree on a method to record the time spent and the actual cost.
I think this should be favored because the involvement of in-house counsel in an arbitration is fundamental to make the arbitration more efficient.
Yeah.
In my experience, when clients just go with the outside counsel and do not provide support, do not consider arbitration as another project which has a cost and income balance sheet, then this makes the arbitration more time-consuming.
But let me challenge a bit, and I would here like to have the audience views also a bit. I mean, on the other hand, you could say, of course, a company is always facing difficulties. It will always have a dedicated employee who has to deal, be it with some problems at a specific plant where a specialist must be hired and dedicated to deal with that problem, or be it with an arbitration. And should that really be cost that should be taken into account, you know, in a cost allocation, as you have just said, because they dedicated truly their time on this arbitration? Or is it something where you can say, yeah, these are employees, they are hired to do the business, and within the ordinary course of the business, for most of the companies is, of course, also the fact that you have to deal with disputes and that you have to represent the best way possible and assist the best way possible outside counsel in a specific dispute situation, the cases and the facts, you have to be prepared, etc. So I would like to know just who here in the room, just very generally, of course, there are always exceptions, would be in favor that in-house costs, lost executive time, or in-house counsel that have been dedicating their time to an arbitration, that these costs should be taken into consideration in cost allocation. May I ask you to raise the hand? And who is against it? I have to get a feeling.
Gabriele, the real answer is it depends.
Yes, that's anyway. If we lawyers are no longer able to respond to a client, it depends. I think we would all be out of work. But it was still interesting to see. So the vast majority is for a reimbursement or reallocation of this cost, and that means to take this cost into consideration. Thank you. That was very educative for me as well. Let us go to another situation that we very frequently encounter in practice. Yes, please.
That's why I said that the question is for me too short. My understanding is that...
Is there a microphone, please, for Ulrike? A box.
So, no, that's why I think the question to me is a bit short, whether to allocate or not to allocate. Mm-hmm. It's more a question of how to do it, and I think it's something at the very beginning of the proceeding. One should discuss that with the parties, if and to which extent in-house counsel or in-house fees are to be compensated. And I mean, on the one hand, it's anyhow costs. That's what we would consider. I mean, the guy's there. Probably you don't employ somebody simply because you're just having that lawsuit. But the question is then, how do you demonstrate that that person, you know, you needed to shift work, or that the work of that person was substantially reducing lawyer fees? And I think this is at least what must somehow be demonstrated, not only by a timesheet, but that's the minimum to show at least that it's not additional cost, but it reduced in external costs. And of course, then you must say, what is your in-house rate, whatever, which hopefully is substantially below external fees. And then you come to this, into the discussion of saying it could be compensated because had the lawyer done that, it would have been much more expensive. So that's why I think I couldn't say yes or no to your question.
Sounds very reasonable. We come back to this transparency and the question of whether these cost factors should be discussed at the outset of an arbitration in a minute. But let me ask the last question before I give the word again to the audience, also to raise maybe other factors that could be relevant in cost allocations. We very often encounter situations where one party wants to bifurcate the arbitration proceedings. It's very standard, I would say, in particular in big damages claims, that they want to go first for the liability phase and then for the cost determination. What if at the end, you find out that actually this bifurcation has not, as it was sold to the arbitral tribunal, lead to more efficiency, to leaner structure of the proceeding, but actually complicated the proceedings? Should it be then that the party that proposed or pushed a bit more through this bifurcation, or actually pushed it through, should that party be somehow punished by having to take over more costs?
Well, I think it depends. Because bifurcation sometimes is fundamental. You have situations where even the applicable law is not clear from the outset, or where the seat of the arbitration is controversial between the parties, and so you don't want to start a case with so frail basis. And you have other situations where it is clear that it could be an efficiency measure depending on the outcome. Because, of course, if you give a certain answer, a certain decision, this could stop the case, or perhaps the case goes on. In such a case, I think it's a question of discretion of the tribunal, because if the tribunal decides that it makes sense to have a bifurcation, and then, however, the result of the bifurcation goes against the rationale of the request made by the party, perhaps the tribunal should consider this at the end, because at the end, bifurcation was not a means through which you achieved more efficiency, but actually created higher costs and a longer time for reaching the final decision. So it's a tricky issue.
I agree. Let me just add one thing, because for me it has become sometimes very difficult to address that topic. I think in a vast majority of the cases where I see that there was not a predictable outcome of the questions for which bifurcation was asked, I think it would be not fair, to punish a party. That's for me clear. But there are cases where you at the end as a tribunal feel somehow unjustifiably being dragged into a bifurcation. You see that it was a dilatory tactic, because if they start arguing the question for which bifurcation was asked, you can see there was not much, really, hardly nothing that really supported that perspective, and you clearly can see it was maybe more a dilatory and obstructive tactic deployed by one of the parties. I think these are, in my view, exceptional cases where I would probably reconsider as an arbitral tribunal whether to shift certain costs because of this request of bifurcation that has been raised. In most of the circumstances, it is the discretion of the tribunal. If they say, yes, we do bifurcate, I think it would be mainly or mostly unfair, maybe, than to punish a party. Before we go to our last topic, are there questions from the tribunal with regard to cost factors that should be taken into consideration that we have not yet addressed?
Well, another cost factor could be a cost factor that has been incurred before a court in connection with ancillary proceedings. Mm-hmm. For instance, when a party is objecting to the jurisdiction of the tribunal and is going to lose that. In some jurisdictions, of course, the court will also decide on the costs of that specific court proceeding, but this could perhaps be considered by arbitral tribunals as well.
Mm-hmm. That's for sure. Other?
Third-party funding, impact or success fee?
Do you want to use the mic?
No, my question is over. My question was success fee, third-party funding. How would you consider that? Or would you consider that positive or negatively in any cost decision?
Now you tackled on one of the issues that nobody wants to respond to, but which is very, very interesting. In fact, I mean, we are all are aware that in arbitration success fee agreements are in place. We also know that third-party funding is in place, and we all know that there might insurance companies be in place who take over costs. Should this be taken into consideration?
Again, nobody wants to answer the question, right? But I would say no, and perhaps you can address it at the beginning of the proceedings by, stipulating how costs should be recorded, because, if you record counsel work in a way that you would, like, regardless of who's paying, then perhaps it doesn't matter if there's a third-party funder involved. And I mean, yeah, I don't know. I don't have a good answer.
Well, it all depends. The
I forgot to say it all
funding
depends.
is a relatively new animal as defined. I used third-party fundings more than 15 years ago without telling about it anybody. As a counsel, I represented clients who received an external support for third parties, which became anonymous for the rest of the players. Now it would be considered unfair, but at that time nobody dreamed about third-party fundings. So I think that the practice will develop.
Can I say one more thing?
Yes, of course, Anja.
No, so I mean, if you're going to take third-party funding or insurance situations into account, then you also must have some sort of mandatory disclosures. So as it is
That's
now,
exactly the
you
issue,
can't have it, you can't take it into account if you know about it. Then you must require from all parties that they have to disclose it first.
I think this is exactly the tricky issue, the disclosure, which is hardly ever done. And another factor that also maybe should be taken into consideration at the end, you have to ask yourself as an arbitral tribunal, is these factors, success fees, insurance that is in place, third-party funding, something that, would it not have been in place, would that naturally have increased the cost that that party could claim in this arbitration? If the answer is yes, I think there would be some fairness in actually awarding some cost on that, but of course you should know. And with this last remark, I would like to go into the next topic and last topic, and that's transparency with regard to cost allocation. What is expected and what is needed? Massimo, do you enlighten us a bit?
Yeah, and we'll be short because many points have been already touched upon. Transparency is one of these sexy words that sometimes circulate in the arbitration community. In this context, transparency basically means foreseeability, predictability. It means that the parties from the very beginning are aware of the impact in terms of costs of their choices. Because even, lawyers could decide, the defense tactic, that they are going to file a claim which is overstated. This could be a legitimate decision if this is going to have an impact later on, in case the party is winning, but is winning a lower amount. This should be clear from the very outset. Now, how do you achieve predictability? We have to start from whether you are in ad hoc or in administrative arbitration, because if you are in administrative arbitration, you have at least some guidelines, at least all these reports from the SEC. The SEC tell you what is the trend. There may be agreements between the parties, but certainly I think it's a duty of the arbitral tribunal to be clear from the very beginning. And there are the instruments to achieve that, because now we have, in the SEC context, there are the terms of reference. We have the first case management conference. In that moment, it would be very nice if the arbitral tribunal would tell to the parties, we don't know, of course, the outcome. We cannot tell you how expensive is going to be this arbitration, nor we can tell you who is going to win on the costs. But the rules of the game are the following ones. Also because the expectations of the parties have to be protected. Parties coming from certain jurisdictions give for granted that the principle is cost followed event. I heard with interest the presentation of our American friend. The idea that you add insult to injury when you award the legal fees to the losing party in a continental law context sounds a bit strange, because in a continental law context, If you have been forced to go into litigation in order to protect your right, you are the party that has to end up at the end in the same exact position in terms of its wealth, its assets, it was before the breach of its rights. All the costs which result from the fact that you are forced to litigate in order to protect your rights are damages. And as damages, they should be fully recoverable. On the other hand, I don't want to contradict myself, but if you come from a continental law context, very often you see that normally the winning party does not get the full amount because there is some element of, how can I say, set-off compensation. And many jurisdictions have rules about that, rules that could be put on the plate immediately. I mean, the people should be aware from the very beginning of what the rules are. You can have situations where the behavior of the parties during the proceedings is taken into account, situations where the financial condition of the parties is taken into account, situation where the issue at stake, if it's a legal issue, which is open to many different, it's a difficult legal issue, perhaps the losing party should be protected for the fact that the case was a difficult one. Vice versa, if it's a frivolous claim, even the American rule, I know there is an exception to the American rule, if you are litigating in bad faith, then you may be condemned to be paid also legal fees. So even the American rule in some way follows the cost-following event principle in extreme situations. And so this is predictability. Predictability is also linked with efficiency because all our discussions here are we have to be efficient, and we think normally efficiency is a quicker arbitration with lesser costs. I think this is too simple because you evaluate efficiency in light of the quality of the product. You could have a situation where the arbitration is lasting much less because there is no reasons, or perhaps the reasons are very, very simple. But we all think and believe that a good award is an award which contains convincing reasons. But to write down convincing reasons, you need time, and time increases the cost, but the quality of the product is a higher one. So at the end, I think there is no clear-cut rule, but for the need to be clear from the outset to the parties about what are to be the rules of the game, and perhaps at the end of the proceedings, to be always trying to achieve justice by giving reasons also for what concerns the allocation of the costs. Because sometimes the awards are too quick. When they get to that point, sometimes they are too quick. And giving reasons is fundamental, in my opinion.
Thank you very much. It's a really well-balanced answer. I mean, we have heard this now many, many times. I think, Philippe, you also before we've heard that this cost discussion should take place at the outset of the arbitration. But how detailed should it be? Should the criteria, the specific criteria, already be discussed? So, what's your view on that point?
I don't know. I mean, it depends.
You learn.
It depends on the relationship between, you know, the members of the tribunal and the council. I think at the beginning of a case, as you know, as the parties and the tribunal are just trying to establish a good working relationship, it might set sort of a negative atmosphere if you go into, you know, too much. If you sort of talk about criteria, and I guess that goes more to council conduct. But yeah, I think when it comes to like the criteria or the standards upon, you know, or how the general approach, maybe that's what I would settle for. You know, you should have a discussion, but sort of frame it in a sort of general way. I don't know.
So you would not go into the specific criteria, but have a general discussion with the parties here. Again, yeah.
This is also something that, you know, it doesn't have to be the tribunal dictating what, you know, how they are going to make this assessment. Mm-hmm. It could be an open conversation to the extent that that kind of relationship at that point in the arbitration already exists between the parties and the tribunal.
This is a point where I would like to satisfy very briefly my curiosity. I mean, how many of you have actually had discussions with tribunals or were as arbitrators discussing cost criteria at the outset of an arbitration, at the case management conference? Okay, that are very few. That's not surprising for me. How many of you think this should become a standard? That the institution should have it as a standard for like the procedural timetable that must be discussed, that also costs are discussed with the parties at the outside of an arbitration?
It depends.
Gabrielle,
It depends.
Gabrielle, you should precise the first question. I guess that the minority who discussed the issue of cost did it rather as to the arbitrator's remuneration than on the parties' representatives.
I think there is a judgment call to be made by arbitrators at the outset and take into account the experience of the parties and counsel to the parties on both sides. I mean, there are cases in which you have so experienced counsel that you don't need to tell them that the statement of cost will have to be filed after the post-hearing briefs, for instance. But there are other cases in which you may have an imbalance of experience or simply a very different cultural background. And in that sense, I think it's useful to at least raise the question, see if the parties can agree on a way to submit such cost, on what such cost may be, and just openly discuss with the parties. Now, some arbitrators feel reluctant to do that because they feel that the more they discuss the issues with the parties, the less flexibility they will enjoy at the end of the proceedings. And I think, again, they should warn the parties that there are a number of factors that are to be taken into account when allocating costs at the end. It's not a simple case of winning or losing, and that procedural conduct may be taken into account. I agree that it should not necessarily be in a boilerplate procedural order number one, but at least you should remind the parties that the tribunal has this power. So I don't see any issue in raising the questions with the parties, trying to find an agreement at the beginning.
And a perfect agreement would be if both parties agreed on the hourly rates paid to their counsels.
Okay. Any other views on this interesting topic on how and to which extent cost allocation should be discussed by tribunals at the outside of the arbitration? Philippe? Then Bruce, sorry.
Well, I believe in both instances when you decide to bifurcate proceedings in various issues and various phases, but even if not, if various issues are to be decided, I think you should discuss in principle to the extent loser pays or relative success applies, whether that applies in the overall context or by issue. And if you do bifurcate, you have to discuss with the parties whether separate cost statements for each phase will be submitted. And if you render an award after each phase, whether that award should include the costs, because depending on whether or not you're allocating costs after a phase, that will as well substantially change the dynamics and the positions between the parties. So I think that matters and the tribunal should address. And even if there's no bifurcation, maybe, again, from the perspective of incentivizing the parties to conduct the proceedings in an efficient manner, it may make sense to explore with them whether they see a way to maybe submit their cost statements by allocating their legal costs and other costs by various issues, because again, even if you decide the matter in one final award, it may make sense to apply the loser pays principles by issue. Let's say jurisdiction or maybe liability in principle. I mean, maybe the claimant is awarded only a very small portion of the amount it is claiming, but the vast majority of the cost and expenses has been incurred in relation to proving whether there was a breach or not.
Thank you. Bruce?
Thanks. I'd just like to get the panel's views on dealing with costs at the end of the case and whether it's appropriate to deal with it in the award on the merits or whether it's appropriate to have a separate phase once the parties know what might be a difficult factual matrix in terms of the extent of success on various issues, how much was awarded at the end of the day, whether you feel it's appropriate to have a separate phase where the parties can take that into account and make specific submissions on the costs phase.
I'm not so sure whether I understood the question. So your question is
The
that
question is whether it's appropriate in some circumstances for the tribunal to issue an award on the merits and say that the claimant has won on these issues, and this is how much we award. But we're not going to deal with costs yet. We want to hear you. Now that we know the extent of success, we want to hear submissions on costs in relation to that.
Well, there is a case where this is the only way you can do that, is when you have this sealed offer thing, because you don't want the tribunal to know in advance, before deciding on the merits, what was the settlement proposal, because this could influence the tribunal. But if this is to be taken into account, because the excess costs have to be charged to the winner, then the tribunal can first decide on the merits, then ask the parties in connection with these settlement negotiations what was the result, and decide on the cost. But apart from that, I think normally you do that at the very end, requesting the parties to...
Exactly, because wouldn't that also actually prompt abusive behavior? I mean, if I would be the losing party, you know, I would definitely make sure that my costs are minimum, that I can say it's unreasonable what the others are asking. I mean, further views on that, on the panel side?
I agree with you. It would create a very strange incentive for the losing party to minimize its cost. Can I say one more thing about the previous topic, just on the sort of what should be discussed at the beginning of the case? Because I just saw last week the cost submissions in a very long-running arbitration, and they were very, very different on either side, right? So either party specified, like the respondent, counterclaimant, specified, you know, hours spent on each issue, each written submission, and so on. And the claimant submitted, you know, a one-pager saying, we spent this much money on legal representation over the past however many years. And so the tribunal, by not addressing in the beginning how the cost should be reported and substantiated, has closed the door on like awarding costs on an issue-by-issue basis, right? Because if you don't know if the claimant actually has that information, but so I think it's probably, even if you don't decide how exactly at what criteria, you know, costs will be awarded in the end, just sort of communicating to the parties how they are expected to report and substantiate their hours, or their costs rather, is probably a good idea.
Yeah. Question is here whether this needs to be done at the outset of an arbitration, at the first case management conference, because I rather see it more typically done, you know, at the end, you know, very typically also at the end of a hearing where the tribunal is explaining and also discussing with the parties the further course of the proceedings, and in that context, cost submissions are addressed.
But at the end could be too late, because perhaps the party has not, in good faith, set up a mechanism to properly record whatever is to be recorded. And I don't see why the rules of the game should not be clear from the very beginning. We are not saying how you're going to apply them, just the rules. Because then the strategy may be completely different, and the way of handling costs.
We have very institution representatives here. I think they all have to go home and make sure that their rules are revised, and that from now on, one standard part of the procedure order number 1 or terms of reference or whatever it's called under various rules has a standard criteria that needs to be addressed by the tribunals with the parties' cost allocation and cost identification. Any other views? Yes, please.
Thank you, Gabrielle. I fully support what Massimo and Anja has said. I mean, we really need to be transparent at the level of the arbitral tribunal. If we're all going to play the same game, we have to have the same rules. And another example is the in-house counsel. I mean, today we see more and more parties represented or assisted by large legal teams. And that means that already at the very beginning, at the first CMC, you see a large in-house team. So you may expect that these people will be involved throughout the long proceedings from day number 1 until the very end. And so if you don't establish the rule, if you don't clarify, number one, whether these costs are recoverable or not, then parties may have expectations and then they will be disappointed. And number two, also how to record, under which standards. If you don't define the games of the rule from the beginning, it will be very difficult at the end saying, oh yes, in fact, you were charged too much time, too much hours, and how you would justify that the work done by the legal team is superior or necessary or accessory to the work done by the outside counsel. So these things have to be discussed, and it's no problem in discussing this. But since I have the mic, may I ask you another question related to the cost, recoverable cost. I would like to hear from you whether you consider that remuneration of witness is acceptable or not, and if yes, whether these costs are recoverable or not recoverable.
Thank you. Any takers for this question?
Well, in some jurisdiction, remuneration of witness could even be a crime.
Yeah.
That's how you remunerate. If, of course, you compensate the witness for the fact that he's traveling and losing time. Okay, that's. But frankly, as counsel, I would have big problems if my client says, "Can I pay my witness?"
I would be very, very prudent. But what Jose raised brought me to an idea that, in fact, the tribunals learn the parties' expenses along with the last submission. And this is sometimes the moment we learn the hourly rates the lawyers charge. And to answer your questions, I would have some doubts whether it would be appropriate to ask the parties at the outset, how much do you pay your counsels? Huh? What are your success fee arrangements? What is the hourly rate of the leading attorney and of the other one? I'm not sure that the tribunal's discretion could go that far.
Another interesting question. Unfortunately, we are slowly running out of time and would not like to miss the opportunity to give Piotr the word, because he will end this session with a slightly different topic, namely arbitrators' remuneration. This is a sensitive topic that is hardly ever discussed, and while we have now discussed a lot about allocation of costs, within or among the parties, we would like to close this session with this presentation by Piotr.
Thank you. The remuneration of arbitrators is a very, very tested topic and a very sexy one. However, it is still about predictability of expenses or the lack of predictability. I have in front of me the diagram prepared by the ICC Task Force on Cost 2015, and to my astonishment, I realized that in 2015, 15% of all costs in ICC arbitration were allocated to the arbitrators, whereas the 83% to the parties representative plus 2% to the ICC administrative expenses. I remember 12 years ago it was different. It was just something like 8% of expenses were allocated to the arbitrators and the rest to the counsels. And I wonder what has happened. Does ICC pays more to the arbitrators, or the counsel charges less? We have heard Alexis Moore today warning the arbitrators that you will all be penalized with late submissions of the draft arbitral awards. But still, again, this diagram shows what portion of the arbitration cost can be predictable. And I mean that in institutional arbitration, the arbitrator's remuneration is predictable. Some institutions inform the arbitrators at the outset on how much they can expect. The ICC put it between the minimum and the maximum, reserving itself some possibility to modify these amounts. However, in other institutions, especially in Eastern Europe, the parties pays an arbitration fee to the institution, and the institution pays just a share to the arbitrators, and this share may be very, very different depending on the jurisdiction. For instance, in Poland, Polish Chamber of Commerce pays just 50% of the arbitration fee received among arbitrators, and keep the rest as administrative fees. In Russia, for instance, it is different. In Moscow, at MCATS, the administrative fee is 3 times higher than the arbitration fees. And this disproportions of, say, 75 and 25% are new by the parties, but the parties think sometimes that this all money goes to the arbitrators' pockets, which is not true. And it happens that in Russia, an arbitrator may lose on the case, which is sometimes ridiculous. Imagine that the Russian institutions keep 30% of the arbitrators' remuneration on the national income tax. Even if you present a certificate that you are taxable in Poland or in France or in Italy, they disregard such an argument, and they withhold 30% on it. Moreover, they do the same on your expenses. So if you spend 2,000 euros on flights and hotels, you will be paid back just 1,400. So, which makes this institution much less attractive. However, speaking about the expectations, what is predictable, what is not. As I mentioned before, the institutional arbitration is more predictable in terms of arbitrators' expenses and remuneration, whereas ad hoc is not. I started with the ICC under the Dr. Robert Briner presidency, and he had a very nice saying. He said, you know what? Ad hoc is an old Latin term which should be translated into more expensive. In fact, the arbitrators' remuneration in the ad hoc proceedings sometimes are not predictable at the outset. People think it's an easy case, it will take a few weeks, they agree, but then something happens, third-party intervention, counterclaims, and other complications, and the negotiations between the parties and the arbitrators sometimes restart if a cap is reached relatively soon. So some institutions are cheap, some institutions are expensive. The cheapest arbitration I ever had was in Belarus. I rendered 3 awards, all 3 of them in Russian. The total value was something like $2 million US, and after many months and interventions, I was paid $540. I called the secretariat and asked, what is that? Oh, that's your fee. I said, oh, is it really my honorary, but for which of these 3 cases? Oh, for 3 of them. Again, arbitrators who have this experience in various jurisdictions could share some views and opinions that, for instance, it is better to serve as an arbitrator in Romania than in Bulgaria, and better in the Czech Republic than in Hungary for some particular reasons. I guess still institutional arbitration is more predictable than ad hoc, and is more predictable than any public court litigation, and if arbitration became more and more expensive, it's not because that the arbitrators make more and more money on it.
Thank you, Piotr. I mean, it was a very interesting closing presentation on arbitrators' remuneration, and two remarks from my side. I think maybe the arbitrators should be protected, and by giving them more predictability, so you should have a right to ask at the outset what you earn in order to find out. But it shows also that, of course, you know, when we look at the overall cost allocations, it may not be the right point to criticize the institutional or let's say arbitration cost, institutional fees and the arbitrators' remuneration, but where we have flexibility, because we do have to monitor better party costs, and at the end of the day, I think it's not more than just and correct, as we have all heard in our discussions, that if there is inappropriate behavior, not reasonable cost, that this cost should not be then shifted to the other party, but should stay with the party that actually is responsible for such costs. With that, I would like to close that session. Many, many thanks to my esteemed panelists who have contributed greatly to this discussion. Also to the audience, feel very sorry that we could not have taken more questions. I'm sure there would have been more. Thank you very much. It was a pleasure for me to moderate that session. Thank you to the institution for listening.